state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution and Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165 3D calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution? Was the impeachment of the deputy president not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that?
Hey, do you want to know how Mark Chapon made $178,000 in 3 months by dropshipping? Welcome to Spocket. Dropship millions of unique and premium products to sell. Import and push products to your store. Manage your orders or start
from the application of Article 1 and usurp the people's power, when the people are supposed to directly participate in giving their views under Article 118 of the Constitution. My ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 145. My ladies and my lords, the only time Senate was limited was when or if it constituted itself into a special committee. If what transpired in Parliament in the Senate was a matter that was under Article 145, Clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the deputy president, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you have been told that the deputy president avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend professor was carried with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the president and deputy president, starting order number 78(9), and you would have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the president chooses to appear before the Senate, the president shall be required within 3 days of the invitation under sub-rule 4 or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate, in which the president shall set out. He would have told you the mode of appearance. 1, the president's response to the particulars of the allegations. Number B, how the president, and in this case the deputy president, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the deputy president could have appeared. 1, whether in person, 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The deputy president appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was candid with the truth, he would have invited this honorable court to harmonize and to purposively read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the deputy president of the Republic of Kenya, is it then true that he can become a deputy president who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the deputy president if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the president? Is it Mr. Somane? Is it Ndegwa? Who determines that qualification if it is not the IBC?
My Lord, there is something that Mr. Giro is submitting on, which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodho was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to act for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, it will be...
That's a merit issue that is being argued. So are we going to have the opportunity to answer it? Because the law is the opposite of what you say.
It was raised by Mr. Giro. I'm just clarifying, and then Mr. Giro will continue.
To raise that issue, that is my submission, my law. He is going into the merits.
But then Mr. Giro may
just let's sort it. My Lord, it's me who is on record for Professor Kindiki. I think if Mr. Ndegwa, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Ndegwa means. If my friend the Black Bull could keep within the remit of a rejoinder and a reply, we will not be having all these interjections. I've been resisting the urge because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiru time to finish.
I am also obliged, my lords. My lords, finally, let us distinguish the Kisii case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to fight that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is even today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is replied to issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that unlike in war, where you can change facts on the ground, the court does not accept a situation in which one party would be allowed to change facts on the ground in a manner that makes a mockery of the proceedings before it. That is to say, if we are before you on account of the fact that there have been violations in the impeachment process, my Lord, and the conservatory orders that have prevented the completion of those illegalities are in issue, this court should not permit a situation in which a party is able to say that let me change certain facts, as it were, by completing the violations. My Lord, there is a question of public interest. We don't have to say much about it, but coming from the Honorable Attorney General, my Lord, I would only urge that public interest from the Attorney General must also be read, apart from what is directly friendly to the government, must also be read to what is also friendly to the people of Kenya. And that is a desire to ensure that the impeachment process is done credibly and upholding all the rights and the procedures that are in issue. So that it is still possible for the Attorney General to say that public interest in this particular scenario would require that fundamental rights, the case on fundamental rights, be concluded before you can be able to say this or the other person should take office. My Lord, there is the issue of the conservatory orders. I've had to read them again. The one from Justice Muongo, because they have been called as orders of reinstatement or mandatory injunctions. My Lord, I believe and I have a lot of full confidence in the fact that it will not be possible for Judge Muongo to issue mandatory injunction on reinstatement at that level, and as a matter of fact, he did not. The prayers as framed is purely to preserve this matter pending hearing and determination of the petition. So it's a scarecrow argument to say you are seeking reinstatement, you are seeking mandatory injunction. There is no such thing, my lord. Coming to Professor Ojienda, he said many things. There are only two that I wish to respond to. One of these is the observation, his reactions to the fact that to the Senate process and about the Deputy President. My lord, I wish and I hope the court will note the substantial lack of empathy in the circumstances of the Senate about why the DP was not there, what remarks ought to be made and what ought not to be made. Second issue that we wish to make with regard to the issue of Professor Ojienda is, of course, this issue that he said there is no comeback from impeachment and all this, and we proceed and swear. My lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My lord, Mr. Muthomi Thiankolu, my friend, came with these interesting arguments that on the issues of jurisdictions. My lord, these issues of jurisdiction is an interesting one, as we'll see it in a minute. My lord, the first impeachment case that appeared before a 3-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff, and it related from the Embu cases. I don't know whether Professor Ojienda was there, but my lord, it is important to say this with regard to that I actually made the precise argument that my learned friend Mr. Mugobi made about whether the question of impeachment under the constitutions of Kenya was justiciable or not. The 3-judge bench held that it was justiciable, and it is on the basis of that because it relates to the issues of Bill of Rights and procedure. And
my lord, let him also tell you whether it was the impeachment of the president, because my submission was not that impeachment is generally non-justiciable. Even the authority I cited, it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make, for purposes of the argument, the authority is there. For purposes of the arguments, those precise arguments were made. There is actually no distinction when you look at the impeachment for governor under 181, how it is carried out with the one of the president. But one of the significant position that I wish to make from that case is this, that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position.
And talk of reading in. That's a remedy available to this court under Article 23. Reading in can be read into statute or any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we were to look at the travaux, the preparatory documents, allegation, that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Milimo, the Senate sits in a quasi-judicial capacity. Yes, if the Senate sits in a quasi-judicial capacity, Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
Thank you. Thank you very kindly, my lords, my lady. Permit me just to indicate what Professor Githu Muigai Senior Counsel indicated, that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is civil appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that preposition, and it came to a conclusion
Move forward with a name, with a vision, with a first step. The right domain is out there. Get a hold of it and create your site.
Yes, now the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have two, and they will have, how much do you need?
You had given us 30 minutes. If I remember. I am addressing the court, please.
Yes.
Reply to the court. You had given us 30 minutes.
My Lord.
Do we do 15-15 or 20-20?
No, my Lord,
yes.
There is a lot that has been canvassed. In fact, they had given us the impression that they will need less than an hour. They have obviously done 4 hours and something.
No.
There was things that we
okay, let us save on time.
We can do within 30 minutes.
Let's
or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief, is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business, and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30-30. Let's go.
My Lord, may I please the court?
Yes, on what issue?
On the same issue, because I've been standing and I didn't catch your eye. Still on the issue of the right to reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later, not now. And the rejoinder should be on points of law. Yes. Rejoinder should be on points of law.
My lord, I stand guided, but I'd still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues and responded to altogether.
You can pass those submissions to their counsel appearing for the other applicants.
Before counsel proceeds, I am Mwangi Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application which we believe we have a right to rejoinder, a brief rejoinder, and it was one of the applications that was canvassed. So we also have a brief right to rejoinder. Will only take 5 minutes.
My lords, Morara appeared in person and argued his own case.
And I am his counsel.
It is not possible.
We appear together with him in this matter.
Let us give directions, and we will proceed with these directions which my Lord Judge Mrema is going to give. There must be order in every proceeding.
Who is starting? Is it Mr. Yes, proceed.
My Lord, my name is Ochiel Dudley, and it's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is my name. My Lord, allow me to begin with where my very good friend Mr. Somane stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry you're involved in, extends, the court, while conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. Well, that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubt, the court should now feel comfortable. My Lord, during the break, I inquired from my learned friend, Mr. Thiankolo, a very good friend of mine, and I asked him, Dr. Thiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
You want to hear?
When I asked him, by what authority, he told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August 2024, in petition E429 of 2024. Let me come to the other case, the Kisii governor's case. My Lord Justice Ogola, you are familiar with that case. You're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place and that that matter would come before Justice Okwany, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32D of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Mora Kirera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. My Lord, allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both at the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petitioner more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Mwengi Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. My Lord, other cases we agree with, cited by the National Assembly's Kitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you've preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term. It would remain unfilled. That time, we had not yet amended Section 32, capital D of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days. all the three chains of Kenyans court, when required, have risen to the occasion. BBI did not last the 3-5 years my friend Mr. Tiankolu spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Githu Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Prof. Ojienda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petitioner has not pleaded for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Tiankolu bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that, what would happen when, without conservatory orders, you hear the case and the petitioners succeed?
The position of the Deputy President is in a unique
My Lord,
position as defined by Article 2.
as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed
145.7 because it is constitutionally underpinned and not statutorily underpinned.
to reconstitute the IBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his clan,
from Eldoret to this court has never changed. The law firm Mr. Morara operates in is the same law firm that we work and filed this petition under. And this is not a new thing. Even in the BBI case, Mr. Morara was a petitioner and appeared with the counsel.
So what is the issue?
It's the right to rejoinder. We have not been given an opportunity.
My Lord, do you have something to say on that? In the petition which Mr. Morara filed in Eldoret, he filed the petition in person. Today he appeared in this court and urged certain points in person. There are certain matters which he made, and even Professor raised an issue seeking to cross-examine him. And then it turned out that he appears in person. So we need a notice of change,
There is no need.
notice of appointment of advocate for now Morara to instruct counsel to represent him in these proceedings. That is the extent of my objection.
You have
I thought, my lord, you ruled on it unless you're being asked to revisit your ruling.
You have notice of appointment.
My Lord, there is no need for a notice of appointment. The record will reflect that the firm, the pleadings are not filed by Morara in person. They are filed by the law firm. And Mr. Tiankolu also appeared with Morara, in fact, in the BBI matter. So I don't understand why he would object now. And the case went up to the Supreme Court. I only request for 5 minutes.
I think we have come to the end of today's proceedings. We want to take this opportunity to thank you all, counsel, who have presented your client's cases, and even the people who came to see the proceedings. We have sat until late we shall render our ruling on Thursday at 2:30. Thursday is which date? A day after tomorrow? 31st at 2:30.
My lords, perhaps I need your guidance because we had indicated in the morning that we have an application for contempt of court, for which my lady...
Mr. Ndegwa, listen to the instructions and directions of court. We will give a ruling on this matter on Thursday, the 31st at 2:30. After that, we'll provide a way forward for any other matter. Thank you.
I am one guided.